Imagine this. A news report flashes across your screen showing law enforcement seizing just massive amounts of evidence, or maybe even recovering a missing child. Or perhaps a sudden, unexpected knock on your own door.
Hmm.
In these moments, a critical question often surfaces. What legal power, underpins such a profound action, and what does it truly mean for both law enforcement and for you as an individual?
Right. It's a fundamental question.
Welcome to the Deep Dive, where we take complex topics.
Yeah, even the most detailed legal documents and try to distill them into illuminating, digestible insights.
That's the goal.
Today, we're embarking on a deep dive into something that sits right at the intersection of state power and individual rights. Search warrants. We're going to be your guides through a pretty comprehensive set of legal training materials, specifically focusing on how search and seizure, and especially search warrants, operate right here in Texas.
Yeah, focusing on the Texas Code of Criminal Procedure, mostly. Our mission is pretty straightforward. We want to equip you with a foundational understanding of what a search warrant actually is, how it comes into existence, what it allows officers to do, and the very, very precise rules governing its execution.
It's about the how and the why.
Exactly. We'll explore the how and why behind these powerful legal tools, helping you understand their vital role within our justice system. As we navigate this, always keep in mind that inherent tension, the state's very real and necessary need to investigate crime and uphold justice, carefully balanced against an individual's deeply held right to privacy.
It's a delicate dance, absolutely. And the search warrant is kind of the choreography, like you said.
Yeah, it is.
And that tension is precisely why the legal framework around search warrants is so meticulously defined. It's not meant to be about arbitrary power. It's supposed to be about a structured, legally sound process.
Right.
And to understand that process, we first need to get clear on our terms.
Absolutely. So let's unpack this. We hear the term search warrant thrown around a lot. It sounds authoritative, sure, but what exactly is it? How would you define it for someone who isn't, say, a legal expert?
Well, at its core, a search warrant is basically a formal written order from a judge, and it gives law enforcement officers the legal authority, the green light, if you will, to search a specific place and seize particular evidence.
A judicial green light. I like that.
It's for an investigation that directly impacts someone's privacy, so it needs that judicial oversight. Now, under Texas law, specifically the Code of Criminal Procedure, or CCP, Article 18.01a defines it as a written order issued by a magistrate and directed to a peace officer.
Okay, magistrate, not just any judge.
Right. A magistrate in Texas isn't just any judge. It's a specific judicial officer, could be a justice of the peace, a municipal judge, a district judge, someone who has the power to issue these types of orders in criminal cases.
Got it.
And this order, it commands the officer to do one of two primary things. Either one, search for and seize certain property or items and bring them back to the magistrate.
Right.
Or two, in very specific, sensitive cases involving children, to search for and photograph a child to document evidence and then deliver that film to the magistrate.
Wow. Okay, so it's not just about grabbing illegal stuff.
Exactly. It's immediately clear that warrants aren't just for seizing physical contraband. They can also be about documenting conditions or gathering specific types of evidence, especially when, vulnerable individuals are involved.
So it's a specific written command from a judicial officer to a police officer. But what makes that command legally valid? It can't just be based on, like, a hunch or a suspicion from an officer, can it? There has to be some standard for such a powerful intrusion.
You're absolutely right. It's never just a hunch. The cornerstone, the absolute foundation of any valid search warrant is what we call probable cause.
Probable cause. We hear that term a lot, too.
We do. And CCP Article 18.01b is crystal clear on this. No search warrant shall issue for any purpose in this state unless sufficient facts are first presented to satisfy the issuing magistrate that probable cause does in fact exist for its issuance.
Sufficient facts. So what does that mean in practice?
Well, what it means for you is that probable cause isn't just a feeling, right? It's a legal standard. It requires concrete, substantial facts that would lead a reasonable person to believe that, 1, a crime has likely occurred, and 2, evidence of that crime will likely be found in the specific place they want to search.
Okay, reasonable person standard, concrete facts.
Exactly. And to establish this, the law requires that a sworn affidavit setting forth substantial facts establishing probable cause shall be filed in every instance where a search warrant is requested.
An affidavit, so a written statement.
Yes, a detailed written statement signed under oath. And that sworn part is crucial. It means the person presenting those facts, usually a law enforcement officer, is legally on the hook. They're swearing under penalty of perjury that the facts are true to the best of their knowledge.
Ah, so there's accountability built in.
Absolutely. It adds a critical layer of accountability and legal validity to the entire process. It's not just telling a story, it's swearing to facts before a judge.
That affidavit, with all those sworn facts, it sounds like it could contain a lot of really sensitive information, right? Maybe about ongoing investigations or informants.
Definitely.
So is that information just immediately available to the public, or is there a way to balance that transparency with, the needs of law enforcement to keep things confidential sometimes?
That's a great question, and generally transparency is actually a built-in part of the system. Except for some specific exceptions we can talk about, the affidavit becomes public information when the search warrant for which the affidavit was presented is executed.
Executed meaning when the search actually happens.
Correct, once the search is done. At that point, the magistrate's clerk is required to make a copy of the affidavit available for public inspection in the clerk's office during normal business hours.
Okay, so it becomes public record.
Usually, yes. This is a key mechanism for public oversight. It allows citizens, and maybe more importantly, defendants and their lawyers, to review the specific basis for a search that impacts their rights. It's about ensuring accountability for how these powerful tools are used.
So public access is the default. But you mentioned exceptions. Are there ways an affidavit can be sealed from public view, even temporarily? This is where it gets really interesting, I think, that balance.
Yes, there are specific, pretty limited exceptions, which are outlined in CCP Article 18.011. A felony prosecutor can go to a district or appellate judge and request that an affidavit be sealed if they can establish a compelling state interest for doing so.
Compelling state interest. Sounds serious.
It is. It means a serious, legitimate reason for withholding it from immediate public view. There are two main scenarios where this often applies. First, if public disclosure would jeopardize the safety of a victim, witness, confidential informant, or cause the destruction of evidence.
Okay, protecting people or the investigation itself.
Right. It's about protecting ongoing investigations and the safety of the actual people involved. Second, an affidavit can be sealed if it contains information obtained from an unexpired court-ordered wiretap. Revealing that kind of info prematurely could compromise a much broader, more sensitive investigation.
Makes sense. But are these sealing orders permanent?
Oh, no, not at all. They're always temporary. They're designed as a short-term measure, just balancing that immediate state interest with the eventual need for transparency. The order itself expires on the 31st day after the date on which the search warrant was executed.
So about a month.
Roughly, yeah. And there's a very narrow window for extension. A prosecutor can request only one 30-day extension, and that has to be based on a new finding of compelling state interest requested before the original 31 days are out.
Only one extension, okay.
And here's a crucial point. Even when an affidavit is sealed, that sealing order does not prevent the disclosure of other key information. People can still find out about the contents of the search warrant itself, its return, meaning what was done with it, or the inventory of property taken.
So the fact of the search and what was taken isn't secret.
Correct. And importantly, it also doesn't affect a defendant's fundamental right to discovery. They still get access to the affidavit's contents eventually because they need it for their defense. The system tries to provide temporary protection without completely undermining due process.
That's a lot of very specific rules. Yeah, all aimed at finding that balance. It really highlights the precision required here. So let's talk about the source of this power. We know a magistrate issues them, but who specifically holds this immense authority? Is it just any judge on the bench?
No, definitely not just any judge. The authority is quite specific and often tiered, actually, especially for certain types of warrants. When it comes to what are commonly called evidentiary warrants, those issued to search for and seize items that are direct evidence of a crime.
Like the ones under 18.02.
Exactly. For those, Texas law restricts the power to issue them to a very particular set of judicial officers. These include judges of municipal courts of record or county courts, but only if they are licensed attorneys in Texas.
The attorney requirement.
Yes. Also, statutory county court judges, district court judges, judges of the Court of Criminal Appeals, and even justices of the Supreme Court of Texas. Essentially, these are judges with significant legal training and experience in criminal cases. The idea is to ensure a high level of legal review for these evidence-based warrants.
So the more potentially impactful the warrant, the higher the level of judge required, generally speaking.
That's a good way to put it, yeah. The intent seems clear. elevate the judicial authority required as the warrant's potential impact increases. There are some practical allowances, though. For example, in counties that don't have one of these specifically listed attorney-licensed judges.
Like smaller rural counties, maybe?
Potentially, yes. In those counties, any magistrate can issue certain types of search warrants, including those for evidentiary items or contraband subject to forfeiture. This ensures law enforcement can still function effectively everywhere.
Okay, a practical exception.
But there's a stricter rule for subsequent search warrants. If they want to search the same person, place, or thing that has already been searched under an evidentiary warrant.
Going back for another look.
Right. In those cases, only a judge from a higher court like a district court, a court of appeals, or the state's highest criminal or Supreme Courts can issue that follow-up warrant.
So increased judicial scrutiny for repeat searches.
Precisely. It underscores the gravity of repeated intrusions into privacy. And there's another very specific application. Any magistrate who is a licensed attorney can issue a search warrant just to collect a blood specimen from someone arrested for certain intoxication offenses, like DWI, if they refuse a breath or blood test.
The blood draw warrants.
Exactly. Shows how detailed the law gets, even for common scenarios.
That's a really deep dive into who can issue them. It's clear it's not a blanket power. It's very hierarchical, specific, depending on the county, the type of warrant, even if it's a repeated search. Makes sense, given the power these warrants hold.
It absolutely does. The level of judicial authority really seems to scale with the sensitivity and potential impact of the warrant.
Okay, so the law isn't stuck in the quill pen era, in this, increasingly digital age. How have search warrants adapted to technology? Can they be applied for electronically, maybe over the phone, or does it always have to be a physical in-person process with paper?
Right. Yeah, the law has significantly modernized to keep pace. Huge changes here. Under CCP Article 18.01b1, magistrates can now consider information communicated by telephone or other reliable electronic means when deciding whether to issue a search warrant.
That's a big deal. Fast responses, right?
Exactly. It allows for much quicker responses, especially in urgent situations, while still maintaining rigorous legal safeguards. For instance, if testimony is taken over the phone or electronically, the person providing it must first be placed under oath, just like they would be in person.
Still sworn testimony.
Absolutely. And if someone electronically attests to an affidavit, the magistrate must acknowledge that attestation in writing. The key here is that even when applying remotely, the process meticulously mirrors the rigor of an in-person application.
How so? What kind of safeguards?
Well, if the magistrate considers additional testimony or exhibits remotely, they have very specific recording and preservation duties. They have to record that testimony word for word could be electronically, with a court reporter, maybe even written notes.
Cool.
All those recordings or notes then need to be transcribed, certified as accurate, and preserved. Any other written records or exhibits also have to be signed, certified, and preserved. It's all about maintaining a clear, verifiable, legal trail, even when it's happening digitally.
So it's definitely not just a casual phone call. It sounds like a fully documented, legally robust remote process.
Yeah.
How does the actual warrant get, issued in this electronic environment? Is there a digital signature or some kind of duplicate process?
Precisely, yeah. The goal is efficiency and legal authenticity. So the officer applying for the warrant prepares what's called a proposed duplicate original. They then transmit its contents word for word to the magistrate.
Okay.
The magistrate then takes those contents and puts them into what becomes the original search warrant. And this is where it really embraces the digital age. If the contents are transmitted electronically, the transmission received by the magistrate may serve as the original search warrant.
So the electronic copy can be the original?
It can, yes. Now, a magistrate isn't just a rubber stamp here. They can modify a submitted warrant. If they do, they must either transmit the modified version back to the applicant electronically, or they file the modified original themselves and then tell the applicant to modify their duplicate accordingly.
Communication is key.
Absolutely. For the final steps, the magistrate signs the original documents, notes the date and time of issuance on the warrant, and then either transmits the signed warrant electronically back to the applicant or tells the applicant to sign the judge's name and enter the date and time on their duplicate original.
So the officer signs the judge's name?
On the duplicate, yes, but only under the magistrate's specific direction after the magistrate has signed the original. This duplicate original process is really crucial for efficiency while ensuring legal validity.
Okay.
Then there's a powerful legal protection built into these modern methods. Evidence obtained from a search warrant where information was provided electronically or telephonically is not subject to suppression on the ground that issuing the warrant in compliance with this subsection was unreasonable under the circumstances, absent a finding of bad faith.
Meaning it's hard to get the evidence thrown out just because it was done electronically?
Pretty much, yeah.
Yeah.
Unless you can show the judge acted in bad faith, the process itself is considered legally sound. It provides robustness to this evolution of legal practice.
That's truly remarkable how the legal system has worked to keep pace with these technological shifts while hopefully maintaining its integrity.
It's a constant balancing act, but yeah, an essential one.
So we've talked about how a warrant is obtained, the probable cause, who issues it, even how it's done electronically. Now let's turn our attention to what happens once this powerful document is actually in the hands of law enforcement. What does it actually empower them to look for and seize? Is it a free-for-all, or are there very specific categories of items they can take?
Oh, it's absolutely not a free-for-all. CCP Article 18.02 is incredibly precise about this. It lays out the explicit grounds for issuance. Basically, a comprehensive list of what a search warrant may be issued to search for and seize. This article is where the law gets into the real nitty-gritty of what legally constitutes evidence.
Okay, so what's on the list?
Well, the law itemizes many categories. For example, a warrant can be issued for property acquired by theft or in any other manner that makes its acquisition a crime. Pretty straightforward stolen goods, basically.
Right.
Also, property specifically designed or commonly used in committing an offense. Think of like burglary tools or maybe specific disguises used in robberies.
Tools of the trade.
Exactly. Weapons prohibited by the penal code. Illegal firearms are a big one here. Gambling devices or equipment, targeting illegal gambling operations, drugs, controlled substances, or related property or apparatus. That's a huge category for narcotics investigations.
Yeah, I bet.
Then there's any property the possession of which is outright prohibited by law, just inherently illegal stuff. And implements or instruments used in the commission of a crime a bit broader, covering tools used in various offenses.
Well, it's a pretty detailed list.
It is. What's clear from this exhaustive list is that the law isn't casting a wide net randomly, right? It's meticulously itemizing specific types of evidence linked directly to criminal activity. It shows a deliberate rather than arbitrary approach to what can be seized. The overarching principle is always a clear connection or nexus between the item and the alleged crime.
Okay, nexus.
Now, one of the most critical and frequently used categories is what we call evidentiary search warrants, covered under Article 18.02. This allows warrants for property or items, except the accused's personal writings, constituting evidence of an offense or tending to show that a particular person committed an offense.
That sounds pretty broad evidence of an offense.
It is quite broad, but it comes with strict requirements. Remember that probable cause standard. For this type of warrant, the affidavit must establish 3 specific things. First, that a specific offense has definitely been committed. Second, that the particular items they want to seize constitute evidence of that specific crime. And third, that those items are located at the specific person, place, or thing they want to search.
So even for that broad category, the link between the item, the specific crime, and the location has to be crystal clear in the affidavit. That makes sense. But what about highly sensitive locations, like, say, news offices? Are they treated differently, given the importance of a free press in our society?
They absolutely are, and this is a crucial exception designed specifically to protect journalistic integrity and freedom of the press. Under CCP Article 18.01e, a search warrant cannot be issued under that broad evidentiary category 18.02a10 if the items they're looking for are located in the office of a newspaper, news magazine, television station, or radio station.
Whoa, okay. A specific prohibition.
Yes. And furthermore, the law explicitly states that such items, things that are only evidence and not, say, stolen property or illegal weapons themselves, cannot be legally seized in any search of these news offices, even if they somehow had a warrant.
So a double protection for journalistic materials.
Exactly. It's a very specific carve-out to prevent law enforcement from seizing journalistic work product or sources, unless, again, that material itself falls into one of the other categories, like being stolen property. It protects the news gathering process.
That's important. Okay, beyond physical items and news offices, what else? Can a warrant be issued for a person?
Yes. Interestingly, a search warrant can even be issued for persons under 18.0211. And if the probable cause also shows that person has committed an offense, the warrant can, in addition, order their arrest.
Okay. And what about things related to asset forfeiture?
Right. A warrant can also target what's called contraband subject to forfeiture. Think of it this way. These are items that aren't necessarily illegal just to possess, but they're connected to a crime, often a felony, and can potentially be seized by the state because of that connection through that asset forfeiture process. For these warrants, the affidavit has to establish probable cause that a specific felony offense has been committed.
Okay, specific felony link for forfeiture items. The digital age, though. This must bring entirely new challenges to this whole concept of search and seizure.
Yeah.
What about your cloud storage, your social media messages, data on your phone? How does the law handle those less tangible locations and protect our digital privacy?
That's where the law has really had to scramble to adapt, creating new categories specifically for electronic data. CCP Article 18.02A13 allows for warrants targeting electronic customer data held in electronic storage. That's pretty expansive.
Like what?
Well, it covers things like the contents of your Google Drives, your Snapchat messages, Instagram DMs, Facebook posts, data held by service providers. Now, under a related law, Article 18B.354, only a district judge has the authority to issue these specific warrants. And notably, it applies regardless of whether the customer data is held at a location in this state or another state.
So they can get data held by a company in California, for instance.
Potentially, yes, with this type of Texas warrant. The probable cause requirements remain strict, though. A specific offense must have been committed, the electronic data they're seeking must constitute evidence of that offense, and it must be held by that particular service provider.
Okay, what about the device itself, like my phone?
Even more specific is Article 18.02A14, which covers searching a cellular, telephone, or other wireless communications device. This addresses the unique challenges of mobile devices directly. And here is a really significant protection for your digital privacy. Under Article 18.0215, peace officers may not search cell phones or wireless devices pursuant to a lawful arrest without a warrant.
Wait, say that again. Even if I'm lawfully arrested, they can't just search my phone.
Generally, no, not without getting a separate warrant specifically for the phone. The Supreme Court case Raleigh v. California established this principle nationally, and Texas law reflects it. Just being arrested doesn't automatically give them the right to rummage through your digital life on your phone.
That's a huge protection.
It is. And warrants for these devices have very detailed application requirements identifying the specific device, its owner or possessor, and clearly stating the facts showing probable cause that criminal activity is connected to the device and that evidence will likely be found on the device.
Okay, so usually need a warrant for the phone itself. But are there any exceptions? What if there's like a real emergency?
Good question. Yes, there are a few very narrow circumstances where an officer might be able to search a device without a warrant, assuming it's not prohibited by other law. These include if the owner or possessor gives their explicit consent.
Okay, consent is always an exception.
Right. Or if the device has been reported stolen by the owner. Or if the officer reasonably believes the device is in the possession of a fugitive who already has a felony warrant out for their arrest.
Trying to track a wanted fugitive.
Exactly. And the last one is if there's an immediate life-threatening situation. And that's defined very narrowly. Think hostage crisis, a barricaded subject, or any other emergency where someone is directly threatening another person with death or serious bodily injury right then and there.
Okay, truly life or death scenarios.
Yes. However, and this is a critical safeguard, even in those dire circumstances, there's a post-search requirement. If a search is conducted under the fugitive or life-threatening exceptions, the officer must apply for a device warrant as soon as practicable after the search has already happened.
Apply for the warrant after searching.
In those limited emergency exceptions, yes. But here's where the judicial review comes back in. If the judge reviews the situation later and finds that the immediate life-threatening situation or the fugitive scenario did not actually occur as the officer believed and therefore declines to issue the warrant after the fact, then any evidence obtained from that warrantless device search is not admissible in a criminal action. It gets suppressed.
Wow. So there are serious consequences for getting it wrong.
Absolutely. It emphasizes strict judicial oversight and prevents these emergency exceptions from being, stretched or abused.
That makes sense.
Yeah.
Any other specific warrant types we should touch on?
One more worth mentioning is a specific type for photographing an injured child, outlined in CCP Article 18.021. This warrant allows officers to search for and photograph a child believed to be a victim of certain serious offenses, like injury to a child, sexual assault, or continuous sexual abuse.
Just for photos.
Yes, to document injuries or conditions. The affidavit has to establish probable cause that a specific offense occurred, that evidence like injuries can be detected by photographs and the child's location. When executing it, a law enforcement photographer can accompany the officer. Critically, the officer or their assistant conducting the photography must be of the same sex as the alleged victim.
Important sensitivity safeguard there.
Very. And the child cannot be removed from the premises just for the photos, except under specific family code provisions about child removal. All photos taken are immediately taken possession of and delivered forthwith right away to the magistrate. It really demonstrates the law's attempt to balance investigating terrible crimes with protecting extremely vulnerable individuals during the process.
That's incredibly detailed, and yeah, it really highlights how the law attempts to be both comprehensive and sensitive to the context.
So, okay, once a warrant is properly issued, it has to meet strict formal requirements too, right? It's not just a casual note from a judge.
Oh, absolutely not. Beyond just having probable cause backing it up, the warrant document itself must meet strict formal requirements outlined in CCP Article 18.04. Think of it as a checklist to ensure its legal validity and prevent any ambiguity about what's authorized.
Okay, what's on the checklist?
First, it shall run in the name of the state of Texas. That establishes its official governmental authority.
Standard legal formality.
Right. Second, it must identify, as near as may be, that which is to be seized and name or describe, as near as may be, the person, place, or thing to be searched. This specificity is crucial. It prevents those dreaded general exploratory searches. Officers can only look where and for what the warrant says.
The particularity requirement. Exactly. Third, it must command any peace officer of the proper county to search forthwith the person, place, or thing named. Forthwith means immediately or without unreasonable delay, emphasizing the urgency once probable cause is found and the warrant signed.
Get it done promptly.
Fourth, it must be dated and signed by the magistrate. Obvious, but essential. And fifth, the magistrate's name must appear in clearly legible handwriting or in typewritten form with the magistrate's signature. No mystery about who authorized it. Clear accountability.
Okay, it makes sense. So the warrant's issued, it's signed, it's specific. Now, what happens on the ground? What are the actual procedures officers must follow when they go to execute that search warrant? This is where, the rubber meets the road.
Exactly. This is where that rigorous legal framework translates into real-world action. The execution of a search warrant is governed by very strict procedures under CCT Article 18.06, designed to protect both the integrity of the search itself and the rights of the individuals whose property is being searched.
Okay, step by step. What do they do?
First, the officer who receives the warrant shall execute the warrant without delay and shall return the warrant to the proper magistrate. That without delay echoes the forthwith command on the warrant. They shouldn't just sit on it.
Okay.
Upon arriving at the place to be searched, the officer has a crucial duty regarding transparency. They must present a copy of the warrant to the owner of the place if he is present.
Show them the paperwork.
Right. If the owner isn't there but someone else is in possession of the place, the officer gives the copy to that person. And if nobody's present at all, the officer must leave a copy of the warrant at the place in a conspicuous spot. So notice is given, one way or another.
Okay, so people know why they're there. What about taking stuff?
Right. Now imagine an officer has lawfully entered a home. Before they take anything from the place, they shall prepare a written inventory of the property to be taken. This isn't just bureaucratic red tape, it's a vital step for accountability.
So they list everything they seize.
Yes, before taking it. It means officers can't just search and grab indiscriminately. They have to list exactly what they're seizing based on the warrant. The officer then has to legibly endorse his name on the inventory, sign it, and present a copy of the inventory to the owner or other person in possession of the property, or, again, leave a copy if no one is present.
So you get a receipt, basically.
In a way, yes. It ensures a clear, documented record of precisely what was seized. That's essential for any potential legal challenges down the road and just for the person knowing what happened to their property.
That's reassuring. So it's not just search and grab. There's a meticulous documentation process built in. What about timing? Are there deadlines for executing these warrants? They can't just hold on to them indefinitely, can they, waiting for the perfect moment?
That's absolutely correct. There are strict time limits for execution detailed in CCP Article 18.07, and these time periods specifically exclude the day the warrant was issued and the day it is executed, giving you whole days for the process.
Okay, whole days. How many?
Yeah. For most typical search warrants, the period allowed for execution is 3 whole days.
3 days. Seems short.
It does emphasize that forthwith idea. However, for those warrants we talked about for electronic customer data held in electronic storage, like that Google Drive example,
Yeah.
the period allowed is longer.
Yeah.
10 whole days. This longer period reflects the often complex nature of dealing with digital service providers who might be in other states needing time to comply.
Okay, 10 days for electronic data warrants.
And for warrants issued solely to search for and seize DNA specimens for analysis like blood or saliva samples, the period is even longer, 15 whole days. This acknowledges the specific logistical challenges involved in collecting and then processing biological evidence.
15 for DNA. Got it. What about seizing a phone or computer? Does the analysis have to happen within those time limits too?
Good question. There's a very significant nuance for digital devices here. If a warrant is issued to search for and seize data on a computer, phone, or other electronic device, the warrant is considered to have been executed within the time allowed if the device was seized before the expiration of the time allowed.
So seizing the device itself counts as executing the warrant.
Exactly. And this is a practical adaptation to the realities of digital forensics. It means officers have to physically seize the device within the 3, 10, or 15-day window, but the analysis of the data contained on that seized device can then be recovered and analyzed after the expiration of the time allowed.
So the digging through the data can take longer.
Right. This allows officers the necessary time for thorough digital examination, which, as you can imagine, can often take weeks or even months, far beyond that initial execution window.
That makes a lot of sense for the complexities of digital forensics.
Yeah.
Okay, shifting gears slightly. What if officers are executing a warrant for, say, stolen TVs, and they're lawfully inside the house, and suddenly they see something else totally unrelated that looks obviously illegal, like, I don't know, a bag of drugs on the coffee table or an illegal sawed-off shotgun in the corner? Can they seize that even if it's not listed on the warrant for the TVs?
This brings us to a really critical legal principle known as the plain view doctrine. It comes largely from U.S. Supreme Court cases like Horton v. California.
Plain view.
The core idea is this. If officers are lawfully present in a location, for example, because they're executing a valid search warrant for those TVs, and they see an item out in the open.
In plain view.
Exactly. And the incriminating nature of that item is immediately apparent, meaning it's obvious just by looking at it that it's illegal or evidence of a crime.
Like the drugs or the illegal gun.
Right. Then they can seize it, even if it wasn't specifically listed in the search warrant they came in with. The Supreme Court clarified that officers don't have to stumble upon it purely by accident. The key is they just have to be lawfully present where they are when they see it.
So lawful to be it, lawful to see.
That's a great way to remember it. If they have a legal right to be where they are, and they see something that is obviously illegal or evidence of a crime right there, they can generally act on it and seize it.
It's a pretty significant expansion of authority for officers who are already lawfully present. And speaking of power, what about the people who happen to be present during a search warrant execution? Can officers detain them? And also, I read something about officers asking for help from citizens during a search. Is that real?
Yes, to both, surprisingly, under specific circumstances. Let's take the citizen help first. Under CCP Article 18.08, an officer executing a search warrant may call to his aid any number of citizens in this county who shall be bound to aid in the execution of the same.
Wow, bound to aid, like posse comitatus.
Kind of like that, yeah. It's a really surprising legal power, though you might not see it invoked much in modern policing. It definitely underscores a historical concept of community responsibility in law enforcement. It's still on the books.
Fascinating. Okay, what about detaining the occupants?
Right. Regarding the detention of occupants, the U.S. Supreme Court case Mueller v. Mena back in 2005 directly addressed this. The question was whether police officers violate the Fourth Amendment by detaining innocent occupants of a home where a search warrant is being executed for the entire duration of the search.
And the answer was?
The court ruled no. Officers are explicitly allowed to detain the premise's occupants while the search occurs. This isn't considered an unreasonable seizure under the Fourth Amendment. Rather, it's seen as a reasonable measure for several reasons. Primarily, officer safety, preventing occupants from fleeing if contraband is found, and preventing them from concealing or destroying evidence during the search.
So securing the scene includes securing the people in it.
Generally, yes, for the duration of the search. While it's certainly an intrusion on their liberty, it's a legally recognized one aimed at ensuring the safety and integrity of the search operation.
Okay, so they can secure the scene, including the people. When the specified property is found, What's the immediate next step? Is it just taken into police custody right then?
Yes. Once the property that was directed to be searched for and seized is found, under CCP Article 18.09, the officer shall take possession of the same and carry it before the magistrate.
Carry it before the magistrate, literally.
Not always literally right that second, but they take custody and it becomes part of the legal process overseen by the magistrate. The term seizure in this context is defined pretty broadly. It means the restraint of property, whether by physical force or by display of an officer's authority, and includes the collection of property or the act of taking possession. So basically, getting control of the item and taking it. And if the warrant also directed an arrest, the officer shall also arrest any person whom he is directed to arrest and immediately take such person before the magistrate. Now, there's also that specialized rule we touched on for gambling devices under CCP Article 18.095.
Right, the circuit board thing.
Exactly. In a search involving gambling devices or equipment, it's at the officer's discretion to seize only the programmable main circuit board if that board is the essential part providing the gambling information. It's a practical measure, right? Streamlines seizing evidence from bulky machines. The officer then just carries that circuit board before the magistrate and retains custody of it as the seized property.
Makes sense for bulky equipment,
Yeah.
much more efficient. And what about the physical warrant itself and all the seized property? How are they handled after the search is complete? Where does it all go?
Good question about the follow-up. Under CCP Article 18.10, the officer must return the search warrant document itself to the magistrate, not later than 3 whole days after executing it. This is a formal step, kind of closing out the warrant.
Okay, return the warrant.
When returning it, the officer shall state on the back of the same, or on some paper attached to it, the manner in which the warrant has been executed. They also must deliver to the magistrate a copy of the inventory of the property taken into his possession under the warrant, again, reinforcing that accountability and documentation we discussed earlier.
So the judge gets the warrant back and the list of what was taken.
Correct. The officer who actually seized the property shall retain custody of it until the magistrate issues an order directing the manner of safekeeping the property. This ensures a clear chain of custody. And a significant rule here is that generally, property may not be removed from the county in which it was seized without an order from a magistrate in that county.
Keep it local.
Generally, yeah. It helps maintain local control and ensures proper legal procedures are followed within that jurisdiction. However, there are practical exceptions. For example, the law explicitly says, nothing herein shall prevent the officer or his department from forwarding any item or items seized to a laboratory for scientific analysis.
Ah, so evidence can go to the crime lab, even if it's in another county.
Exactly. That ensures essential forensic work can proceed. Another exception allowing removal without a specific court order is for property seized pursuant to those warrants for blood specimens in intoxication offenses that might cross county lines, as mentioned in CCP Article 18.067. Again, ensuring essential investigations can proceed efficiently across jurisdictional boundaries.
So search warrants are clearly powerful, essential tools for criminal investigations. But warrants aren't just for criminal matters, are they? What about things like safety inspections or public health concerns? Can warrants be issued for those kinds of inspections?
That's an excellent question. And yes, they absolutely can be. CCP Article 18.05 specifically provides for warrants for fire, health, and code inspections. These warrants can be issued to a fire marshal, a health officer, or a designated code enforcement official from the state or any county or city.
And what do they allow?
Their purpose is to allow the inspection of any specified premises. Could be a business, could be a residence sometimes to determine the presence of a fire or health hazard, maybe an unsafe building condition, or a violation of any fire, health, or building regulations, statute, or ordinance. Think restaurant inspections or checking for unsafe electrical wiring in a building.
Okay, public safety focus. Is the probable cause standard the same as for criminal warrants?
It's distinct. While it still requires probable cause, it's not limited to specific knowledge of an existing violation. In determining probable cause for these inspection warrants, the magistrate is not limited to evidence of specific knowledge, but may consider broader factors.
Like what?
Things like the age and general condition and purpose of the premises, any records of previous violations or hazards found there, the type of premises, obviously a restaurant might get inspected more often than a regular home, and even the presence of hazards or violations in and the general condition of premises nearby the place they want to inspect.
So they can look at the neighborhood context too.
Yes. It allows for more proactive enforcement based on broader patterns or preventative measures for public safety, rather than just waiting for, say, a fire to happen or someone to get sick. Cities and counties can designate specific code enforcement officials for this purpose. There's also a very specific limitation, though, in counties with a population of 3.3 million or more, basically Harris County.
Okay.
These inspection warrants cannot be issued to code enforcement officials specifically for inspecting unsafe building conditions or building regulation violations. That's a unique geographical carve-out in the law.
Huh. Interesting local exception. But that's a fascinating distinction in the probable cause standard overall, allowing for that more proactive approach to public safety. Now, let's tackle a topic that often sparks, well, intense debate and public discussion. No-knock versus knock-and-announce warrants. When can officers actually enter a home without knocking first, and what's the rationale behind that?
This is indeed a highly sensitive and, frankly, often controversial area of law and practice. The U.S. Supreme Court, way back in Wilson v. Arkansas, 1995, established the baseline. The Fourth Amendment ordinarily requires officers to knock and announce their authority and purpose before entering a home to execute a warrant.
The knock-and-announce rule.
Right. It's deeply rooted in common law and serves several important purposes. It aims to prevent violent confrontations by clearly identifying the entrants as law enforcement, not intruders. It protects individual privacy by giving people a brief moment to compose themselves or answer the door. And it allows individuals the chance to peacefully open their doors, reducing the need for property damage through forced entry.
Seems reasonable, but you said ordinarily.
Exactly. The Wilson court also clarified that this is not an inflexible rule. Courts have to evaluate the reasonableness of an entry, including whether a no-knock entry is justified, on a case-by-case basis. The exceptions to the knock-and-announce rule are based on the officers having reasonable suspicion before they enter that knocking and announcing would be dangerous, futile, or counterproductive.
Okay, what kind of situations justify that reasonable suspicion?
There are generally three main justifications recognized. One, that knocking and announcing would present a threat of physical violence. This might be based on an occupant's known criminal history, especially a propensity for violence, or maybe specific intelligence indicating they are armed and likely to resist.
Officer safety concern.
Primarily, yes. For instance, if intel suggests the occupants are known drug dealers who routinely possess firearms and have threatened violence before. Two, that knocking and announcing would be futile or a useless gesture. For example, if the occupants already clearly know the police are there, maybe they saw them pull up, or they're yelling threats from inside, or if there's evidence, they'd simply ignore the knock anyway.
Okay.
And three, that knocking and announcing would result in the likelihood that evidence would be destroyed. This is particularly common in drug cases where evidence like powder cocaine or pills can potentially be flushed down a toilet or otherwise disposed of very, very quickly.
The destruction of evidence concern.
Right. If officers can articulate this reasonable suspicion based on specific facts in their warrant application and convince the magistrate, then a no-knock warrant can be obtained, specifically authorizing officers to enter without prior warning. The main purpose is usually twofold: protect officers from potentially armed occupants, and prevent that rapid disposal of contraband.
So it's fundamentally about officer safety and preserving the evidence they have a warrant for. But there are obviously disadvantages and significant risks to no-knock entries too, aren't there? This is where a lot of the public concerns seem to come from.
Absolutely. The major disadvantage and the primary source of public concern and tragic incidents with no-knock warrants is that an occupant might reasonably believe they are being attacked by criminal home invaders rather than law enforcement.
Yeah, I can see that. Terrifying.
It is. And consequently, they might try to defend themselves or their family, leading to incredibly dangerous and potentially lethal confrontations for everyone involved, occupants and officers. It's a nightmare scenario for anyone unexpectedly roused by a sudden, forceful entry in the middle of the night.
Whereas knock and announce tries to avoid that confusion.
Exactly. In contrast, the knock and announce entry is designed precisely to prevent such deadly misunderstandings. Officers knock, loudly announce police, search warrant, and then wait a reasonable amount of time before potentially forcing entry. The goal is a peaceful entry that reduces risk for everyone. The disadvantage, of course, from a law enforcement perspective, is that those few seconds of warning could give occupants just enough time to grab a weapon or try to destroy evidence.
It's a trade-off.
It is. But what's really fascinating here, and maybe complicates the debate, is that while the legal distinction between no knock and knock and announce seems quite significant on paper, the practical difference in how they are actually carried out can sometimes be surprisingly minimal in terms of time.
How so?
While the law doesn't clearly specify how loud the knock and announcement must be, nor does it set a precise minimum time officers must wait after announcing before they can force entry. Case law talks about a reasonable time, which depends on the circumstances. So in reality, the difference might only be a few seconds between what's technically a knock and announce entry, a quick knock, yell, then immediate breach, and a full no-knock entry.
So the practical gap might be smaller than the legal one suggests.
It can be, yes. And this raises important questions about the real-world impact versus the legal principle, and it certainly fuels the ongoing debate surrounding the use, necessity, and risks of these types of entries. People are constantly weighing the perceived necessity against the very real potential for tragic harm.
That's a really important point, the theoretical versus the practical application. It's clear that while the law aims for clarity, the actual execution on the ground can be very nuanced and, fraught with real-world implications and dangers.
Indeed, it really highlights the constant tension and the incredibly difficult split-second decisions that are often made in law enforcement operations.
Okay, so given all these rules, all this complexity we've discussed, the affidavits, the judicial review, the execution procedures, the potential for legal challenges, what are the overall advantages for law enforcement in going through all the effort to obtain a search warrant in the first place? Why not just rely on exceptions more often? Why go through this whole process?
That's a fundamental question. Despite the seemingly intricate process, the advantages for law enforcement in obtaining a search warrant are actually substantial, and they primarily center on strengthening their case legally and protecting their actions from later challenge.
Okay, like what?
Firstly, and perhaps most critically, evidence seized pursuant to a search warrant is generally much more readily accepted by courts. When evidence is obtained through a judicially authorized warrant, it carries a strong presumption of legality.
The judge already signed off on it.
Exactly. This significantly strengthens the prosecution's case because that evidence is far less likely to be suppressed or thrown out due to Fourth Amendment violations compared to evidence seized without a warrant. That process of demonstrating probable cause to a neutral magistrate beforehand creates a strong foundation for admissibility. It's like getting pre-approval from the judicial branch.
Okay, stronger case in court. What else?
Secondly, an officer acting under a warrant may be protected from civil liability. When officers are executing a valid judicial order, a search warrant, they are generally shielded from civil lawsuits alleging their actions violated someone's Fourth Amendment rights. The warrant provides a clear legal defense, showing their actions were authorized by a neutral arbiter, not just an arbitrary exercise of their own power. This qualified immunity aspect is crucial for officers doing a demanding job.
Protection for the officer. Makes sense.
And lastly, obtaining a search warrant often shifts the legal burden in court. If evidence is challenged, the burden may shift to the defendant to show that the evidence was seized illegally. Maybe prove there was a specific defect in the warrant, the affidavit, or how it was executed.
As opposed to
a warrantless search, where the prosecution usually bears the heavy burden right from the start to prove that a valid exception to the warrant requirement applied and that the search was constitutional. With a warrant, the starting assumption is often that the search was legal, and the defense has to overcome that presumption.
So it flips the script in court, potentially.
It can, yeah. It demonstrates the warrant's significant power in a legal context, making it a cornerstone for effective and lawful law enforcement operations, despite the upfront effort involved.
So we've covered a lot of ground. What does this all mean for you, the listener? We've journeyed through the pretty intricate world of search warrants, haven't we? From their precise definition and that absolute cornerstone of probable cause.
The foundation.
To the modern methods of their issuance, even electronically. We've explored the expansive scope of what can actually be searched for and seized, physical items, digital data, special rules for kids, and news media.
Right, the different categories.
We've also delved into the detailed protocols for executing a warrant, the notice, the inventory, the strict time limits, even the surprising power of officers to detain people on scene, or maybe even call citizens for aid.
And those special circumstances like health inspections and the whole knock and announce debate.
Exactly. It truly is a system constantly trying to balance state authority with individual rights, a tension that really shapes our justice system.
And as you've hopefully heard, that balance is meant to be a highly structured, legally defined one, not just arbitrary.
Right. And understanding these legal instruments, well, it doesn't just demystify confusing news reports or hypothetical scenarios. Hopefully, it makes you a more informed citizen, aware of both your fundamental rights and the powers that are legitimately exercised by law enforcement under specific rules. It lets you see the structured, regulated nature of what might otherwise seem like just random police action sometimes.
Knowledge is power, as they say.
It really is. So as we conclude this deep dive, maybe consider this provocative thought for the road. How might the increasing digitization of our lives went? I mean, think about it. More and more of our personal information isn't in a file cabinet. It's stored in the amorphous cloud or on constantly evolving digital devices. How might this continue to challenge and reshape that traditional concept of place in search warrants?
That's a big question.
Yeah, we've seen some adaptations already, like the electronic data warrants. But what future implications might this have for our privacy? And how will legal precedent continue to evolve to keep pace with technology that is constantly pushing the boundaries of what even constitutes a searchable location in the eyes of the law? Something to think about.